couple, both accused of the aggravated sexual assault of a child in their care that resulted in the birth of a baby, appeared before Jefferson County Criminal District Court Judge John Stevens on April 1st for announcement hearings. Joshua Booker, 32, of Beaumont, and Danielle Davis, 30, of Port Arthur, both currently reside in the Jefferson County Jail on charges of aggravated SA of a child, which resulted in the pregnancy of a child younger than the age of 14. According to the affidavit for their arrest, Beaumont Police Department Detective Frank Coffin III was dispatched to the Medical Center of Southeast Texas on August 12, 2022, in reference to a 12-year-old who had just given birth. The baby was delivered, doctors believed, at approximately 37 to 38 weeks gestation. Estimating conception occurred around the first week of December 2021. During the investigation, the juvenile's family members reported that the male who impregnated her was an adult family friend, cousin. However, Child Protective Services, the investigator, advised Coffin of inconsistencies with the family's account and that she was leery of this and suspected Booker to be the father of the child. The child's mother was later interviewed at the Garth house and, according to the detective, it was clear that the victim had been coached. Davis, who was legally responsible for the safety of the victim, later responded to the police department to speak with detectives. At first, Davis denied knowing the juvenile was pregnant, or even who could have been the father. Davis later admitted to detectives that Booker was the father, and she had not notified the authorities because, if Booker was arrested, Davis would have lost his income as the two were partners. Davis advised the detective that she knew Booker had been sexually assaulting the juvenile approximately 2 months prior to the juvenile getting pregnant, because the victim had made an outcry to her. Davis stated that she instructed the juvenile to lie to investigators about her outcry that Booker had been sexually assaulting her and fathered her child. Davis reportedly made no attempt to protect the juvenile she was legally obligated to protect. Booker's DNA was collected and matched as the father of the victim's infant child. Just when you think humanity cannot get to a lower level, they dig deeper into the ground and seek a lower level of existence. We're talking about a 12-year-old giving birth and no one coming forward with the truth on how the child became impregnated, Stevens observed, and scheduled subsequent hearings for update. Booker's court-appointed attorney, Donald Dusler, advised Judge Stevens that his client wished to have a trial separate from Davis.
Let me ask, are you Joshua Booker?
Yes.
Mr. Wilkerson is your attorney right there? He's appearing through Zoom. Hey, I'm looking at this motion from the state.
Yes, Your Honor. Yes.
What you're alleging is he's committed a crime.
Yes, sir.
What are y'all doing about that?
We're going to look into
I mean,
filing
have a
that.
trial if y'all
Yes,
are going to come forward with more than indictments. Go ahead.
Yes, sir. I believe it, at the very least, it's a misdemeanor threat. So we'll see about getting that filed. I have to have somebody go out and talk to the victim in that case that the threat was made to.
I don't know that a terroristic threat couldn't necessarily be made out because of his ability to commit or not commit an offense if the government's evidence is indeed substantiated. I'm not sure about a retaliation case, though.
No, the states that the defendant sent messages promising to kill the father of Paige Davis. Who's Paige Davis?
It is sinking.
Killed somebody. That is, let me speak. Well, that's a threat that's an illegal act. I mean, I'm sorry, that just doesn't fit within the freedom of speech when we're talking. And how does it affect a pending case? How does is that involving this case? Is the threat directly related to this aggravated sexual assault of a child charge?
No, sir, that threat is not, it's to another individual, but he's just using those communications to threaten not only via the kiosk messages, but also then admitting that on the jail calls, calling these individuals, continuing to speak with them.
Okay,
But there's also been three-way communication between where the defendant calls Geraldine Davis or Paige Davis. They all live in the same household. He's calling them and they're then three-waying with the other co-defendant, Danielle Davis, and they're on the phone together with that as well.
okay. So what are you asking for?
For the court to essentially not allow them to be able to use the jail communication to communicate with anyone outside of the jail. Until we, yes, sir, Your Honor, go to trial on.
What do you say, Mr. Wilkerson?
Your Honor, Mr. Booker has been locked up pending trial for quite some time. He's
about this.
currently set on $150,000 bond. Judge, we had filed for a reduction in bond to try and allow
No,
him.
no. One catastrophe at a time. The motion to prohibit defendant's jail communications. What do you say about that? Let's take that one and then the other one.
Judge, we have no objection to that.
Well, that will be done. You will have no access to communications from outside, communications that go outside the jail. Do you understand? Also, the state can pursue whatever additional charges they wish to make. Plus, this is the kind of evidence that at a trial gets to come out. And that doesn't help you in your situation. Juries don't ever find that amusing. But we're adults here and you can make, you have freedom to make choices, even poor choices. So you are hereby ordered to have no access to communications through the jail system or any other method of communications outside the jail itself.
We would ask, Judge, that communication with his attorney or attorney's office be excluded from that.
That isn't allowed. That's the only exclusion. But here's the problem with that is how do we monitor that? Because people aren't going to be listening to that. They shouldn't. That's confidential. But what's to prevent him from, while confidentiality is going on, getting calling somebody else with the proposition that it was to call you?
I'm not sure if the system is able to limit phone numbers dialed or not, to be honest with you.
Look, Marcus, if it's not, you're gonna have to just go see him in person.
Yes, sir.
All right. That's what I want to do, because unless I'm certain, he's lost his communication privileges.
Your Honor, I was just informed by Captain Minter from the Jefferson County Sheriff's Office that the defendant could go through book-in via Zoom call to his attorney to communicate that away. So they would provide that, but he would have to go to book-in to have that call
Do
with
you
his attorney.
understand that? And that's the only way you're going to be able to talk to him is to request to go through book-in, to call him. Otherwise, he's going to have to come see you, which are privileges you have lost. The jail is going to be able to monitor this if there's any determination made that he is outside the rule, the order of the court, which is no communications, phone, text message, or otherwise to any party outside the jail. Then the court needs to know. Also, I asked the state to look into any additional charges that
Yes, sir.
when people are threatening from the jail, that's forbidden.
Yes, sir.
It's forbidden to threaten anybody, much less being used, being in jail and being able to communicate disturbing messages. That's irresponsible, but it's forbidden. What else, Mr. Wilkerson? Those will be the orders of the court. So what do you want next? Go ahead.
Well, Judge, so our motion was for a reduction in bond before these issues were ever raised. I feel like the court through GPS monitoring and house arrest could be able to fashion rules that would essentially prevent issues like this from occurring in the free world as well. But still allow Mr. Booker to secure a bond to be able to he's expressed interest in hiring a different attorney. Of course, he has no way to make money while he's locked up. And he apparently had been receiving some benefits that, of course, have been stopped because he's currently in jail. So
I want you to explain to me how in, let's say a home confinement with GPS, how that is more restrictive and secure in preventing disturbing, threatening messages to others than the jail is.
it's not, Judge.
Can't prevent it. You haven't been able to articulate to me any reasonable method that being outside the jail, we could prevent this from happening.
I would agree with the court that it's not more secure than a corrections facility, Judge.
Saw what happens, what has allegedly happened here. Threats have been made to kill people from the defendant while he's been in the jail. It certainly is not going to be more secure out in the free world to prevent disturbing messages like that that are criminal in nature. Even it may be a misdemeanor, it may be a felony, but it's still a crime.
And Your Honor,
Can't threaten to kill people.
I'm sorry. I do have.
And then if you're using interstate commerce, that's probably a federal crime.
I do have the text messages that he sent through the kiosk where he's promising to kill the father of Paige, and they all live together too, is my understanding. The Paige Davis, her mother, Stephanie Davis, as well as Geraldine, her sister. So he's promising to kill Paige's father, Stephanie's husband. They all live in the same house over some money. So the state believes that the bond, if anything, would be increased, but certainly not reduced in this case.
Okay, what else?
That's it from the state.
Well, I mean, you've got something in your hand.
Oh, yes,
It
Your Honor.
hasn't
I do
been
have
put into
these. I
evidence.
do have
You wanna
these.
put something into
Yes, Your
evidence?
Honor. It offer states 1, 2, and 3. These are the kiosk messages that were sent from the defendant to Geraldine Davis. Again, that's the sister of Paige Davis. There's also a jail call, if you want, where he admits to making the threats to Stephanie Davis, the wife of the individual that he was threatening.
All right, have you seen these?
Your Honor, I was provided a copy of the 3 kiosk messages as well as a recorded phone call.
All right.
I
Any objection?
I do still have to object to their hearsay nature for record purposes, Judge, but I have received copies of them.
Okay. Okay, what's the hearsay nature since he's the defendant?
It hasn't been proved up that their storage on this third party facility hasn't been proved up. Him having been the one sending those 3 lettered messages hasn't been.
I do have
Sure.
Captain Pinter here to prove that up, Your Honor.
All right.
Yes, sir.
Call him.
Your Honor, state with Captain Bruce Minter.
Come
the
forward.
Jefferson County Sheriff's
Sir.
Department.
just have a seat right over there in the witness box. Thank you. Come on up.
Judge, also need to point out under the record that under the rules of evidence on the bond reduction, which is what we're talking about here, the rules of evidence don't apply according to the rules of evidence.
I'm sorry, the application of reliance and reliability always apply. Come on up. Raise your right hand, sir. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Lower your hand, sir. Thank you. Go ahead.
Please state your name for the record.
Bruce Mentor.
And where are you currently employed?
I am the captain of records and technology with Jefferson County Sheriff's Department.
Okay. And when messages are, do the inmates there have access to send messages outside of the jail there?
Yes, they do.
And are you over that system there?
Yes, I
that
am.
allows it? How is that recorded? I mean, is it uploaded to something or how is that?
Everything is recorded to the cloud that Smart Technologies is over. Everything phone calls, everything they do, pictures, postal mail, everything goes through Smart Technologies.
And so it all goes through there. Does it identify any individual sending the,
Yes, it does.
and does it identify who those individuals are sending the messages to?
Yes, it does. When an inmate comes to jail, they have connections that they make. The connections are verified, approved through either ID or driver's license and photo to confirm that the person they are speaking to is that person.
So you know who the inmate is sending their communications to.
Yes,
Now, is that system secure there?
it is very secure.
Is anyone is pretty much restricted on who can access that? Okay.
My superiors.
Now, Charlie Witzman marked the state's exhibit 1, 2, and 3. Do you recognize these?
Yes, I do.
And what are those?
Those are text messages sent from the inmate to an outside public user,
And who's the inmate there?
Joshua Booker,
And who did he send that to, these messages?
Geraldine Davis.
Okay. And were these downloaded off of the system there and recorded on that system?
Yes, it was.
And are these a true and accurate copy and representation of the messages that were sent?
Yes, they are.
And Your Honor, I would offer state's exhibits 1, 2, and 3, ask that they be admitted into evidence.
No objection, Your Honor.
Without objection, they are admitted for this hearing.
And
Anything else from the state?
no, Your Honor, that's it. I have
From
no further
defense,
questions.
go ahead, Mr. Weber.
No questions for this witness, Your Honor.
Okay, and,
I would just offer states 1 through 3 to the court, Your Honor.
okay, and in this, this says Joshua Booker, is that the same man we're talking about?
Yes, sir.
Here, in this case, the Joshua Booker, who's in this courtroom here charged in 23 CR 1490 with an indictment alleging aggravated sexual assault with a prior conviction of assault of a family member out of 2014, which is an enhanced first-degree felony offense.
Yes, sir.
Same person. All right. Anything, Mr. Wilkerson, anything else?
No, Your Honor.
Okay, can Mr. Captain Minner be allowed to be released? He's got important duties.
Yes, sir. For this part of the hearing, we have another hearing where he might be needed
Okay,
to come
well,
up right
stand
after
by.
this, but
Thank you, sir. What else from the state?
Your Honor, the state just again believes that nothing else to present other than we just would argue that it shouldn't be reduced to bond.
Okay, Mr. Wilkerson, what do you want to present? Any additional information for
No, Your Honor.
this hearing as well as your hearing to reduce bond?
I would call my client for the limited purposes of testifying regarding accessibility to funds and bond.
Okay, he's on the witness stand right now, and we're gonna turn the camera a little bit so he can be clearly seen. Well, if they just that I think it's that camera right there that we're talking about, and it just shows part of the defendant, but
Change the judge.
there we go. Thank you. Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing, Mr. Booker, shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. Okay, go ahead.
All right. Mr. Booker, are you the same Joseph Booker who is currently under indictment in this case?
Put the microphone please closer to his voice and move him closer, Tommy. Thank you very much for that. Is that-
And at present, Mr. Booker, you have a $150,000 bond, is that correct? I presume he's answered. I can't hear, Judge. So, and Mr. Booker, are you able through selling any assets, borrowing funds, or raising funds through family members able to satisfy the requirements in order to make that $150,000 bond?
Well, the only way that's, I cut the restriction off, the only way I'm able to make it is through, Paige Davis, because she has my debit card. And that's the only contact that I have to make, like, to get outside contact with her. And Mr. Wilkerson, when you came to see me the other day, I also have an income monitor on or whatever. I've been having it since last month, whatever. So that's the only way I can actually get up out of here is because I have money now. She have the access to the money. That's the only way I can get access up out of here is by her through the money.
Why are
Okay.
we, why is he still paying for a ankle monitor if he's in custody?
Because Your Honor, I had got,
Do you know?
yes. Well, I had got the ankle monitor last month. We had a bondsman that was gonna farm me out, but the lady said my bond was too high, so she didn't want to mess with me. So what it was, I was bonding out for a bondsman in Houston, and it was gonna work with me. So I just made a payment, kept making payments. Everything but ankle monitor, I have it on, but Mr. Wilkerson came Monday. He also seen it on Monday, so I does have ankle monitor on right now. That's all.
Okay.
Finally, I do Paige Davis because I have funds at they place well, and she have a debit card and everything, so that's the only way I actually like get a out of it. Is through her, because she does have access to the money,
Okay.
things like that.
That's one way to spend money. But an ankle monitor while you're in custody seems to be an awful waste. Until such time you can get out of custody, but that's a decision that people are making who pay. I couldn't-
So, Mr. Booker, then is it your testimony that you would have no additional way to secure funds except through the communication that's now been prohibited by the court?
Yes, sir. I mean, that's the only way. I mean, not if you can, I mean, that's really the only way, sir. Is by her, whatever. Because at the time of the point, I mean, I can't. I took the phone privileges, so I can't get in contact with anyone like my grandmother. I can't get in contact with anyone. So that's the only way.
Judge, I'll pass the witness.
Go ahead.
Mr. Booker, are those phone calls there pretty expensive at the jail?
Yes. It's like $3 a call.
Are you aware that?
Hold on. Is it unlimited time when you
No,
call?
no, so 15 minutes.
15,
Yes.
oh, $3 for 15 minutes?
Yes. And I've been using, that's.
I'm just always curious about that.
I'm using my money sometimes. Like money on there, she be using her money, like at times put money on there on the phone, and when I need commissary, that's.
Well, it's a privilege. A phone call is not a right, it's a privilege, but privileges can be abused. Like what happened in this case, and you lose the privilege, my goodness sake.
Yes.
Now, Mr. Booker, are also the kiosk messages, are they pretty expensive?
Yes, I think they like $3 or $4 a call, if I'm not mistaken.
Are you aware that you've made around between commissary and phone calls around 6,200 phone calls?
Yes.
And also,
Wait, that's at $3 a call?
Yes.
yes, sir.
Yes.
$18,000 in calls?
Yes.
It's almost $20,000?
Yes. The whole time. I've been incarcerated. I've been having money to get out, but my bond's been so high.
May I ask, Who's paid $20,000? Who's coughing up the money?
Like I said, I get a social security check a month on first and the third, and then she also was helping out, like paying.
Hey, I get a social security check too. I couldn't pay 20 grand on a social security.
Was her. Y'all are.
I make a lot in social security because,
Yes.
but maybe. But we're talking, the most you can make is about 40,000
Yes.
to 50,000 a year. And, okay, but 20,000 of that has been used for calls?
Yes.
Now,
Okay.
Mr. Booker, is that all from your card?
That's not just from my card, it's from my card, so.
What's another, well, if she had referred to John's card, whose card would that be?
It is, I had a son for her, and that's my dead son that I have for her. So it's a cash out card, she just ordered a card through cash out, put her name on it, and then had a card in his name. So what she'll do, she'll transfer the money off of my debit card to her cash out card.
Were you ever receiving funds from another card that was supposed to go to Malaysia?
Yes, I was, but I mean, the card that I was receiving, it was supposed to go to Malaysia. I mean, I don't know what's on that card.
How were you receiving those funds?
Because of the simple fact, I think she gave the card to, Danielle gave the card to her to keep whoever, so.
And so the card from Malaysia, you've been using that for commissary and stuff sometimes?
Some. Then because he also sent Danielle money also.
Your Honor, I'd also note that that is the victim in this case, the 12-year-old victim, that the money was supposed to be going to. And so we'll have people looking
Articulate
into that.
how that worked.
Mr. Booker, and correct me if I'm wrong, that Paige Davis has access to a card that's supposed to be receiving money for Malaysia Davis?
Yes.
And
Wait, who's directed that the money is supposed to be for Malaysia? Is Malaysia, that's the child, right?
yes, Your Honor, and I believe it may be for, is that for child support
Yes.
from her father, Gregory Rhodes, was it? Okay, so child support is supposed to be going to this card, Your Honor. Paige Davis has access to it via Danielle Davis, the co-defendant. Is that correct, Mr. Booker? And Paige Davis has been, I guess, has she been splitting that money between you and Danielle?
Yes.
So the child support that's supposed to be going to Malaysia Davis, the victim, has actually been split between both the defendants in this case.
All right. Then I'm gonna request that the district attorney's office communicate to the judge whose orders were made in that particular case, ordering that money. So that the judge, I guess it's a family court matter. Was that a Jefferson County?
I believe the father lives in Newton, maybe.
I know, but where did the
But
proceedings?
I believe, yes, sir, it was here in Jefferson County.
Okay, so they're right down the
Yes, sir.
hall. Yeah, but in all fairness to them, they need to know because they're very sensitive, like all judges are. When we make an order, we demand and expect that it be followed. And those who don't get held severely accountable for it, especially when we're talking about money ordered by a court to a child. When that is being intercepted by third parties and being funneled to parties who are not the ordered recipient, that's criminal. And it's certainly an order violation that can hold people in contempt who are involved in that. I've asked that the district attorney's office, please, in all fairness, get the judge and the parties in that case, who are the attorneys, aware so that they can act. Because what's happening is illegal acts are being run through the county jail now.
Yes, sir.
And I know the jail personnel are very sensitive about security and
Yes, sir.
ensuring that all the rules are followed. And it's being done in a surreptitious manner that needs to be stopped. And we're gonna try to help the jail officials do what they can to prevent further wrongdoing and criminal behavior while inmates are in custody.
Yes, sir.
It's not surprising, it can happen. But this is a real creative method of bypassing the rule of law and committing criminal acts while in custody in jail by people. This is blossoming into a very large net of criminal activity where people are becoming inculpated, that is involved in what I'm hearing in criminal behavior, and it needs to, number one, be stopped. Number two, the people involved need to be held accountable by law.
Yes, sir.
And I'm not, nothing surprises me anymore, but it's something new.
Yes, sir.
Intercepted by third parties and being funneled to parties who are not the people involved need to be held accountable by law.
Yes, sir.
And I'm not, nothing surprises me anymore, but it's something new.
Yes, sir. I have no further questions, Your Honor. From the witness.
Anything, Mr. Wilkerson, from the defense?
No, Your Honor.
All right. Okay, what are y'all asking for, lawyers? Let's summarize. Well, Mr. Wilkerson, you've asked for a reduction in bond.
Yes, Your Honor.
Summarize why that is worthy under the evidence I've just heard in this hearing today. I've only heard worse news. You've got to admit, I've only heard worse news.
I, Judge, like I said, this motion to reduce bond was filed prior to the defense becoming aware of all of these allegations. I cannot argue that there would be circumstances whereby he would be released that would be more secure and preventing communication than a correctional facility. I would say that I believe there could be restrictions put in place that would effectively limit his ability to make those communications while still allowing him to make bond in the case. But Judge, it was set at 150,000. We're asking for a reduction by half to 75.
State.
Your Honor, the state just believes, based on the defendant's statements, he has had access to the money to bond himself out. He's spent probably around 18,000 just on the between jail calls and commissary that he received on there, as well as there's lots more kiosk messages that were also very expensive. And the defendant's continuing to commit criminal acts while in the jail and promising to kill someone when he gets out over money. So the state would just request that the bond actually be increased to $300,000.
Anything else to add? Anybody?
Nothing from the defense.
Did you want to add anything, sir?
Well, sir, I mean,
So we can hear you. Yeah.
well, sir, I do apologize for my acts or whatever, and I just ask, can you be real lenient, and we're asking y'all, can y'all be real lenient on me, and I just ask for a bond reduction, for a reasonable bond reduction. I mean, I Ms. Wilkinson said 75, I support 75.
All right. Okay, the rules for setting amount of bond are clearly provided under Article 17.15 of the Texas Code of Criminal Procedure. And it is to be sufficient to give reasonable assurance that the undertaking, that is, that the defendant would appear in court, in the court proceedings, and the power to order a bond is not to be used to make bail an instrument of oppression. Fairness. is in the equation here. It doesn't say it, but that's what they mean. Be fair. The nature of the offense and the circumstances under which the offense are committed are to be considered. You have to look far and wide to find a more disturbing set of circumstances than the impregnant, the impregnating of a 12-year-old child here by you, a man who is what, 32 years old? And thus the grand jury has charged you with this first degree felony, but in 2014, you were sentenced to 2 years in prison for the assault on a family member. So this offense is now punishable. If all of this is proven true, it is punishable by a minimum term of 15 years imprisonment up to life in prison. You understand that because of the prior conviction. So the bail was set originally, and we will assume that $150,000 was based upon the magistrate's determination that the nature of the offenses, the offense alleged is the nature demanded a high bond. If and we're talking about not only an aggravated sexual assault, but this is of a child of 12 years of age. So the law protects children who have been harmed, especially in a disturbing manner such as this. Also, the future safety of a victim of the alleged offense, law enforcement, and the future safety of the community shall be considered. So while you were in custody on this $150,000 bond, you apparently have been caught on at least 3 occasions threatening to kill others through the phone or text messaging system. And this is all shown through State's Exhibit 1, 2, and 3. And number 3 is, I never play you, I love you, care for you, and promise you about your daddy. So if I don't get my money, all my money, you have play with my freedom. And God bless you. To show you how it felt, and that's on my red mother's soul. I'm spelling words, and I just read that directly, but the inference, of course, is threatening. But State's Exhibit 1, which was a message sent out on August 8th, look, you don't want me out, so I'm going to kill your daddy. I promise he will be you. Took my money, so my grandmother, old man, got y'all. Well, that's very disturbing. And then later on that day, or earlier before that day, there was a longer message that included, let's see.
Oh,
So tell you, daddy, to look out. That's all I have to say. And then threatening people who are apparently involved in the accusation here in this indictment. These are threatening to kill others who are involved in a criminal case, of course, or criminal. And when you're doing it, even if you're sending it out from a jail, that still disturbs people. The safety of the community is at risk, which the law allows us to protect with bail. Bail was set at $150,000. Thereafter, these threatening messages are made by the defendant. And because of not only the charged offense, but his criminal history, he has been convicted of assault. So we know he is capable of, and this was assault on a family member. So we know the defendant is capable of harming others, and family is supposed to be your same blood, and those ought to be people you consider in a more affectionate manner than strangers. But that's not what Mr. Booker considers, and that's not what his actions have been. Then I'm going to grant the state's motion. Your bond is increased to $300,000, sir, due to these additional threats that are made in the jail. And if you happen to post a bond, you will be placed in a home confinement, but you cannot have any access nor communication at any time throughout this trial until it gets resolved with the victim or anyone who on behalf of the victim. And then I can guarantee that there would be no amount of money of bond that could be allowed if you a third time fail to follow the orders of the court. I think also the orders on behalf of the court to the jail that the defendant had no access to communication outside from inside the jail to anyone outside the jail via electronic means of any sort.
In Your
I
Honor,
think that's a global enough to include texts and phones, nor anyone on your behalf act in a way that defies this court's order.
and Your Honor, just to clarify too, the defendant was also sending letters, handwritten letters to the same individuals who were threatened. Just
All
to
right,
make
I'm
the court
sorry.
aware of
And
that. Yes, sir.
no communications at any time. Because of that, no communication is allowed to be sent out unless it is reviewed by jail authorities first. The orders of the court are what they are. But you can send out letters as long as they're not, you can communicate to people, but as long as they're not threatening nor to people that the court has forbidden you to send them to. And the jail has to review them because what you have done while in the jail is very disturbing, to say the least. Threatening to kill people.
I say hurtful things, she said hurtful things. I mean, like this.
Sir, sir, you're convicted felon of violence. You were convicted of a felony assault on a family member and was sentenced to 2 years in prison. Don't say you're not a violent person. You've been proven to be a violent person. You are a certified violent person under law. And you're only showing it worse by these threats to kill people after you have been indicted for one of the most serious types of offenses known to mankind. The sexual assault of a child. All right, is there anything I missed on
No,
dotting
Your
i's,
Honor.
crossing
No, sir.
t's? That is all. We're in recess on this case. All right, what else do I have, please?
The co-defendant Danielle Davis, Your Honor.
Her.
There's an issue with her. I have jail calls where she has called the victim Malaysia Davis and essentially she's tampered with the witness. She
Okay,
has.
is she on the docket today?
Yes, sir.
Who's her lawyer?
Mr. Adams, he's, I think, in the back.
Okay. Bailiff will get it.
All over the place today, Judge.
What else do you have other than her? Is that it?
That's it.
Do you know what the nature of this hearing is?
I think it's,
You were here when we were doing this other hearing on this, the previous person?
I heard some of it, but not all of it. I was in and out. But I got an idea of where he's going.
Well, it didn't work well for the previous person. Come forward. Are you Danielle Davis in 23 CR 889?
Yes, sure.
You were charged with the state jail felony of credit or debit card abuse. And Mr. Adams is here representing you. You're here for another reason. Though this court has received some very disturbing news and information from the jail authorities and the district attorney's office that you are involved in a pattern of threatening acts to others. You have sent messages of threatening acts, and those will be dealt with severely. What's they have to say? Can you explain what we're talking about here?
Yes, Your Honor. The state's been made aware that in their jail calls that were downloaded, that show that Ms. Davis contacted the victim in this case, Malaysia Davis, via her grandmother's phone number, who she's now, it's a Helen Schenkel. The victim is now the grandmother has custody of her, rights were terminated of the parents. Grandmother has custody and the defendant has been contacting the victim via that phone and asking her essentially to say something different than what the defendant has admitted to.
Isn't that kind of a crime?
Yes, Your Honor.
Well,
Tampering with the
grand
witness.
jury needs to move forward
Yes, sir.
and indict.
Yes, sir.
Some additional charges. We're not going to put up with that
Yes, sir.
manipulation.
And ask her essentially to say that in order for her to be able to get out of jail. I have the call as well that I'll try to admit if it's not very long. So if the court would like to hear that.
Yes.
And there's also another call, and there's lots of them, but I just got the one. There's one in which the defendant contacts, again, Geraldine Davis. That's the same kind of group of the same individuals that were living in the same house, Paige Davis from the previous hearing. She contacts Geraldine Davis and then three-way calls to Mr. Booker. And then they're communicating over the phone via basically both jail phones to each other. And so the state has brought this motion to, again, prohibit her from having any communications outside, so she can't tamper with any witnesses, as well as, again, communicating with the co-defendant.
Are y'all proceeding on bringing forth additional charges in front of the grand jury to see if they will indict additional charges for this person's behavior?
Yes, sir, absolutely. I believe it's very clear on the jail call from what was said.
Have you heard these?
I've been provided a copy of it, but
In Your Honor, I would offer State's Exhibit 1. If needed, I can get Mr. Mentor up here to.
I just want to take him on a short, like 30-second voir dire.
Were you here earlier on this other hearing? Because he testified as to.
No, I just want to ask him, just the one question is that can he?
Come on up, sir. Thank you.
Yeah, I heard him. I was sitting down.
Okay. Because he sponsored the presentation of that.
No,
Raise your right hand, sir. Do you solemnly swear or affirm all statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Can you say with any certainty that that is my client's voice on that recording?
Yes, I can.
And then how would you know that that's her voice?
When someone is brought to jail, they have to set up the phone system themselves. It's a two-part identification system using voice recognition and an individual PIN. The voice recognition matched the phone call. I monitored several phone calls, and they're all the same voice.
So when you say voice recognition, your computer system, like Langston Adams, right? My voice is distinct from your voice.
Right.
So the computer system is gonna be able to say, this is Langston and it is not Mentor.
Right.
And what you're saying is your computer system saying that that's her voice and not some other person's voice.
Yes.
But that's not all, right?
No.
There are other methods you have.
They also have an individual pin that the inmate sets up. It is
Okay.
unique to them. The connections that they make on the outside are also approved through them.
Mm-hmm.
So everything ties in together. We match all the phone calls with the voice recordings.
So you're saying that in addition to the technology to identify the voice, the inmate has to type in a particular pin that's only associated with that inmate, right?
Yes.
And in this recording, are you saying my client typed in her particular pin?
Yes, she did. It's the only way she can access it.
And what was her pin?
I have no access to that. That's individual to them.
All right.
Anything else?
Your Honor, state would just, oh, sorry.
No, you're going to introduce.
Yes, sir. Your Honor, the state would offer State Exhibit 1, that's the jail calls.
Okay,
from the defendant.
any objection? I'm not saying we have to listen to it. I think you've got access to it, but
Right.
it's for the purposes of this hearing and for the court's determinations on rulings from the matters in this hearing.
He's saying that it's less than a minute something, so I don't,
Well,
we're gonna play.
This one, these are actually these are probably around 4 minutes, something like that, each of them 4 or 5 minutes. I only really want to play one of them, but
Okay.
I'd want to admit 2 of them, but just play the one where the witness was actually tampered with. In this
That's
case.
fine. If he gonna just play the one where he's saying that the witness is tampered, that's the most important one. That's the one that I'm more concerned about.
Go ahead.
Yes, Your Honor. Asked to play that for the court.
Yes, you may. State's Exhibit 1 is admitted for this hearing.
Thank you.
And again, Your Honor, just to provide the background, this is a phone call made from the defendant Danielle Davis to her mother, Helen Shankle, who is the custodian and the guardian of the victim, Malaysia Davis now.
He said Helen Frankel,
Shankle?
Shankle.
Yes, sir.
And you said that my client called Shankle, and then Shankle in turn had the kid on the phone.
Right. The defendant asked to speak with the victim, and the
Okay.
victim was allowed on the phone. That has been addressed with the grandmother as well.
This is a prepaid call from Danielle Davis, an inmate at a correctional facility. Three-way or call waiting is not allowed and may automatically disconnect this call. This call is also subject to being recorded or monitored except for privileged communications between attorney and client. Please select from the following options. If you consent to this call being recorded and to accept this call, dial 1 now. To reject this call, dial 2 now. Your call has been accepted.
Hello?
Hey,
Hey, was you asleep?
no, I'm trying to keep this baby in
Oh,
give her breathing treatment.
who, Julia?
Mm-hmm.
What's she,
And Your Honor-
what do you mean a breathing treatment?
Jalea is the baby of the 12-year-old.
Oh, okay. When Malaysia?
They have her back down somewhere. Oh, good shit, she back down.
Let me talk to her for a few seconds. Malaysia!
We'll see the previous file, please. That previous case. Thank you. Okay.
You might be here tomorrow.
Who?
Yeah. Well,
Hey, why you taking so slow to come to the damn phone?
open my room.
Huh?
Open my room.
Why you sound like that?
I just woke up. Nothing.
You been good? You sure?
Mm-hmm.
You positive?
Yes.
All right, I love you, little stinky butt.
Mm-hmm.
Yeah, you do. You think I can feel through the phone.
Mama,
What? Lunch in the cold.
that's not my wife.
Keep thinking.
No,
I talked to Aunt Renee yesterday.
you did.
Yeah, I think she's gonna call you out later. Either sometime today though.
Mm-hmm. Did you
Yeah.
take a look?
No, but they was going to vacation Bible school, but I heard Jordan over there terrorizing them.
It's bad.
That's what she was telling me. I
Yeah,
heard she like Jaleel with the little twig in her head.
mm-hmm. Julia likes it.
Huh?
Julia likes all of them. Trigger be running for
Be running from them.
Mm-hmm.
Why you be running from them?
I don't know, because when she's walking out and she's trying to give him a hug, he'd be running from her.
But you doing all right?
Right after.
You doing all right?
Police.
Yeah.
So.
What you mean, so?
Like every now and then I have flashbacks. Other than that, I'm fine.
It's gonna be all right, okay?
Mm-hmm.
You should have told me from the get-go when you first asked it out.
I know,
But I understand he threatened you and stuff like this, so I know you were scared.
mm-hmm.
So you won't, I don't know if they will have you come to court and testify or whatever, but you need to let them know that you didn't tell me until the last minute.
Okay.
My mama could get up out of here.
And Your Honor, just to be clear, the defendant has made admissions to detectives and interviews that she knew well ahead of this, that things have been going on. I think up to potentially 2 years ahead of this, that she was
When
aware.
you say things have been going on.
That she had been,
The
the victim, Malaysia, I'm sorry, Your Honor, Malaysia Davis had been being sexually assaulted by the defendant, Mr. Booker.
Judge, but my brief response is what you actually heard with your own ears, because I was listening just like you, I saw you was listening, is that what I heard the little girl and the mama say is, hey, basically, you just telling me about this and to tell that truthfully in court. I mean, you heard what the lady said.
Is that the end of the conversation?
No, Your Honor, I'll keep
Let's
I'll
listen to
keep
the whole
playing it.
darn thing.
Because to me, that don't sound like.
Let's listen to the whole thing.
And
first.
she also says right after that, so I can get
Yeah.
up out of here. That's different than her statement to the detectives. Also, the victim never said that her mother didn't know until that point. So she's now providing her with information which she needs to tell them, which she told differently to the detectives.
But Judge, you heard it with your own ears. So that wasn't no threat to the kid. And
This
I
isn't a
didn't get no-
debate, everybody. Let me hear the evidence
Yes, sir.
first before everybody starts arguing at one time, okay?
Right, I'm just saying-
Otherwise
right.
chaos. It's not
Right,
gonna be
right.
chaos in this room.
Right,
Some
right.
order for a change.
But-
Yeah,
No, Judge, I'm just trying to
like
make.
kindergarten class all shouting at one time. Don't
Yeah,
do
yeah.
that. Let me hear the evidence before everybody sounds in.
Right.
Jeepers.
Girl,
Okay. So,
I don't know.
so,
They tell me until the last minute.
okay.
My mama could get up out of here.
Okay. So,
I don't know.
so, how does that work, Mama?
I don't know. They probably gonna have to call you for it.
Well, I'm saying that, how does that, wait, what would happen if I testify against him? What would happen?
He'll go to jail.
Well, I know that, but I'm saying, like,
He'll go to jail for a long time later.
that's what I was trying to basically say.
Yeah. If they got you testifying against him,
Hold on, Mama, Papa called, hold on. Well,
Hello? Hello?
That's essentially the end of it, Your Honor. She never gets back on.
Well, Judge, my position is if that's the end, the call actually helps me. It don't hurt me. Because if you listen to the call, and my argument would be, she begins the call where she's concerned about her child.
Right.
Hey, how you doing? You know, what's going on, et cetera, et cetera. And then in the call, I know you heard, Judge, she's talking to the little girl and telling the little girl about how the guy you had in the courtroom, she's acknowledging that dude has been threatening you, not her threatening the child, but that dude was threatening her. And then she goes on to say, I know you heard it, she goes on to say that, hey, I'm really just finding out about how he was threatening you. And then are you going to have to testify in court? Yes. And he is going to get a whole bunch of time because he's got to testify in court. There's nothing in that call I heard where she is threatening the little child. I didn't hear that. I didn't see a threat coming from her.
Your Honor,
So in the argument that I'm making is, in a sense, when he played the call, that call is not what you got in the last hearing. In the last hearing, what you got was somebody with text message saying, "I'm gonna kill you." You don't get that in this. In this, you don't get anything close to that in this. In this particular case, in a sense, that call kind of helps because, in essence, she's saying that the man gonna get a whole bunch of time for what he did. So that's not tampering. That's not saying come to your court and go lie to Judge Stevens. That's not saying, hey, don't come to court and testify against the man that's gonna get a whole bunch of time. That's not saying, hey, I'm gonna hurt you or do you harm. Actually, I think the call helps me.
All right, your
It
point's
helps
been
me.
made.
Your Honor,
Well,
and
you stay.
they don't have to threaten, it just has to be influence or in any way. So again, that's not really that relevant, that what a threat, it could be to influence them. And it certainly did. The child victim has been calling the court staff saying that the child is not his, not Mr. Booker's, constantly after she heard from her mother that he was going to go to prison for a very long time. Ms. Davis also.
Okay. Let me just ask a side note.
Yes.
At the end of the day, certainly you don't have DNA evidence.
Absolutely, Your Honor.
That would be scientific. That is going to overcome any individual's testimony about whose child it is. It's
Yes, Your
going to
Honor.
be scientifically DNA determined, and that's just the way nature is. I mean, that is going to bypass really the weight of individuals. I know the point you're making. You can end because, number one, you're talking to witnesses, potential witnesses in a most serious type of case, sexual assault of a child. Number one, you don't know if that man is going to go to prison for a long time or not, because you're not going to be the jury.
Yes, sir.
And unless the only thing I think you really know about the law is maybe Law and Order reruns,
Yes.
because you're not speaking intellectually about this. Number one, right now, that defendant is presumed innocent under the law.
Yes, sir.
Number next, you're presuming something that hadn't happened, that's not in your power, that he's going to be found guilty. Number two, that he's going to be sentenced to a long time. He might be, but he's presumed innocent. Unless that happens, you're the last person on the planet who would dictate what would happen. Number next is, this is a child that was 12 at the time of the event, so it's maybe the child's 13 or 14. By talking to the child about what could happen and a lengthy prison term under your limited knowledge, you're very limited. And I'm being nice about this. We call this ignorance of the law. You're ignorant of it because that's not the way it works. You're not the determiner. You're just making a prediction. But number one, why are you doing that? There can be only one really obvious reason to make her feel guilty about coming forward and testifying. Because now she's going, you're going to interrupt me? Because he's a 12 or 13-year-old child. I've got children. I had children, little, and they've grown up to be wonderful people. I was 5. I know how children are. They're influenced by people who are close to them, like you. You got no reason talking about this case where she is a vital component as an evidentiary matter in a most serious case, a victim. But you're telling the child, the guys, that person is going to go to jail for a long time. Little children think of prison in a horrifying way. They don't think it's a good place. I don't care what they might be victimized. Children are more forgiving and don't want horrifying thoughts, unlike adults who thrive on that. All that could be done. All that you were doing is trying to make her feel guilty about being a victim and having to testify later, because you were putting on her conscience that going to prison a long time would be her fault. Wrong. That is forbidden in front of me. That's almost sinful. You got no business making her feel bad and talking about what could happen, because you're not in control of it. You're the last person to be on a jury in that case. You'd be the last person on the planet. You'd never get on it because by law, you're too close to it. But it's obvious what, as an objective listener, what you were trying to do, make her feel guilty. So you have lost your phone privileges as well. And the jail is going to monitor. You can speak to your attorney. That's it. But this tampering with witnesses maneuver that for the second time I've heard on a most serious case, which is so transparent and so obvious, is not going to happen again. You've lost your privilege. You understand?
I think she absolutely understands. I agree with you.
Well, we'll see whether, I don't know if she understands or not, but it's the order of the court.
No.
And you violate the order and you'll be in more trouble. And is the grand jury considering indicting her for some additional?
So we're gonna have to get an investigator to write up a statement over this and present that to the grand jury, get one of the officers or investigators to do that. I just got a lot of this information within like the last
Let me
week.
ask, what's her bond in this case?
It was 100,000, Your Honor.
Mhm.
And also, Your Honor, I would just note that Mr. Booker admitted on the stand a while ago that both he and Miss Davis were taking funds off of the victim's child support card and using for their commissary. The only way for Miss Davis to do that was to use these communications outside, calling Paige Davis to get her to do that for them. So that's another
She's lost her
reason. Yes,
she's
sir.
lost all phone privileges except to the lawyer.
And Judge, like I said, in the conversation that was inappropriate, but, and I'm not arguing that point, but just based upon what was said when we started the hearing, and he's just following my logic. To my understanding, the state's position is that she somehow tampered with the witness by threatening the witness, one, and then hold on, and then in the reading of the motion, and I read it word for word, trying to get the witness to testify untruthfully. On neither one of those points did I hear a threat, because I know you was listening too. Did I hear a threat that came from her, one, and then two, I didn't hear anything where she told that little girl, you get to court and you go lie and testify untruthfully. The only thing she said was, is this dude here, he's gonna get a whole bunch of time. Now that's not saying testify untruthfully. That's not saying go lie to the judge. And you heard, so on the things
You made your point,
yeah.
made your point. A reasonable inference from this can be drawn,
Mhm.
and that is not making the child feel guilty,
Mhm.
which would cause reluctance for the child to testify. That's not right.
Right.
And she's speaking about things that she has no authority of anywhere.
Right.
She doesn't have the authority, so why would she pull that out of thin air? She doesn't have that authority. It's a jury to decide whether he's guilty or not for the first place.
Right.
And then a jury to decide, because he wants a jury to determine how much time, not you. And to somebody close to tell a child, he's gonna go to jail for prison for a long time. I was a child too, and I know what I would think of as a child. I know what my children would think of. They think prison is a horrifying place. It ought to be thought that way because there's nothing good about it. But it was in this context only reasonably. You can only reasonably state that you pulled that stunt to try to intimidate the child in testimony later. And that would cause the child reluctance to come forward because children by their very nature don't want to hurt people. Unfortunately, adults evolve. Some adults evolve different from their child behavior, their child instincts. But the innocence of that child, which has been lost in the first place when she was impregnated, is further being tampered with. And I'm not going to put up with that. I'm going to protect little children to the end. And we're going to, this whole due process of law is not going to be interfered with by people like you who don't know any better or don't act any better. Your privileges are lost. On the money thing, this using money,
Yes, sir.
what is the state asking for in a remedy? Because I'm going to deal with it.
As far as that as well, Your Honor, we would just request that also the bond be increased, but we'll certainly try and see how much money was on there to try and look at potential restitution on that, as well as contacting the civil court that ordered that and making them aware of that and seeing what other potential criminal acts were out of that.
All right, I've heard enough to believe that this bond should be increased by what is obvious an attempt to tamper with a witness. I want to know though, there are these, I am limited from what I'm hearing here.
Yes, sir.
But it's for additional, the executive branch of government and either misdemeanor charges or grand jury review that needs to move forward
Yes, sir.
on some other matters to
Yes, sir.
add to the mess that I've heard about already that are in these indictments. We've got additional problems that are being perpetrated in the jail. And that's another reason I'm going to do my best to help the jail employees and the jail personnel ensure that it is a safe environment, and also it is not an environment where additional criminal actions are perpetrated. And I will take extreme actions, and you have now been, your voice has been stifled. You're not going to be communicating except through your lawyer. And then that is the only method, unless there's something that the jail personnel can determine where they listen in. But first of all, it's pretty foolish. Doesn't everybody know over there that those phone calls are being recorded? I mean,
Yes, Your Honor.
why would you? What person with any amount of intelligence at all would start risking further criminal liability when they're being recorded? But generally, the people in jail have made foolish decisions to get into the jail, and I don't expect them necessarily to change their foolish behavior when they're in jail. But your bond is increased to 200. It's double. On what I heard, that is a criminal act of trying to tamper with a witness. Your bond is increased to $200,000. If you post a bond, you will be at home confinement and GPS, and we'll have no contact at all with that child, victim in this case of what the Mr. Booker was charged with.
Yes, Your Honor.
And no one on your behalf will have any contact. I find otherwise, then we'll deal with that. And the problems just keep doubling each time. We're going to have people following the rules. Do you understand? Or else you will pay a high price. And when you're tampering, when we're dealing with children who have been victimized like this, I'm gonna protect them. And hold people highly accountable, and it's gonna sting. I can't imagine. This kind of, a poor child having to go through this. Your behavior has to change. And you have to start acting more like a family member. That's a loving family. That is supposed to represent, as an adult, good role modeling for the children. You're not. Anything else to add? What are we doing about a trial or something?
Yes, Your Honor, we'd asked to set it on the trial docket. We'd been kind of waiting on Miss Davis for the other one to go to trial, but we'd go ahead and set it for the
All
trial.
right, it will be done. And Captain Minner, anything you want to add that in this situation that you feel like the jail needs on behalf of the court under any kind of orders that would ensure that the jail personnel are able to do their job efficiently?
I'll need the appropriate paperwork to turn off everything for both inmates. Everything that's needed, postal mail.
Okay, who's gonna
pictures.
prepare that? I guess,
I could get with the staff, go over that, Your Honor, if you'd like me to, as far as all the communication, except for with the attorneys, correct? Through the, okay.
is a memo that I signed?
As long as it's signed by you, sir. Yes.
Yes, sir. That should be good. Langston, anything you need on behalf of your client here? on
Well, as
this?
long as they keep the communication open with me and her, I'd be fine.
Okay, yeah, that's, I'm not gonna mess with the Constitution.
He'll be able to talk to her and book him either through Zoom or personal.
Yeah, we just want to make sure that it doesn't go out to people other than him.
It'll
And
only
I
be-
trust him. I just don't trust you, and from what I've heard. Anything else? We are in recess. Yes, thank you.
All right, thank you, Judge.
You're good.